All right, we're just waiting for the court. All right. Oh, thank you. Anyway, let's go ahead and set forth our addresses for the record.
Robert Ecker for the plaintiffs, Your Honor.
Maggie Federico for the plaintiffs.
Brianna Surfler for plaintiffs. Mr. Parker and Mr. Teddy Parker and Mr. Eric Kupperman also on behalf of plaintiffs.
Thank you.
Brad Johnson, Eric Freeman, Tyler Watson, and Mike Lessig on behalf of the defendants.
Good afternoon, Your Honor.
All right. Is there something regarding records?
No, Your Honor. This is regarding an issue I want to bring to the court's attention. I believe that defense counsel is thinking of bringing up the Mayo Clinic record, which we discussed in motions of limine. And
what specific and limited?
And that, well, this had to do with the motion for summary judgment for a causation, where you found specific, not only general causation, but specific causation for all of the plaintiff's specific injuries, including Lisa Key's myasthenia gravis. And so I believe that Mr. Mr. Freeman plans on bringing up this record, this Mayo Clinic record, with respect where there was a finding of, it wasn't a conclusive finding, but it was, there was a finding one time that she didn't, that the blood levels weren't at the myasthenia gravis level. Of course, that later became rectified. We went through all this. The court will remember we went through all this with the records. And the main issue is causation on this is established already. And the only reason to do that would be to sow doubt in the jury's mind regarding causation for Ms. King's myasthenia gravis. I would request that the court instruct Mr. Freeman specifically not to try to do that in his cross-examination here today.
Your Honor, I have no intention of doing anything to violate your order of the finding of causation, but I think I have a right to go into the records that he's reviewed and find out what effect that had on his diagnosis of her. What was his reason for, or what is his belief in the differing blood tests? What effect does that have on her MG? Background, of course, of her treatment. I'm not doing anything to challenge causation.
That is clearly a suggestion by doing that, to suggest that there is not a causal link with the hydrazine in real water to her myasthenia gravis. I mean, he could say, oh, it's about how it affected his treatment. It didn't affect his treatment. We're talking about one test at the Mayo Clinic, which was later refuted by other tests. And so it's been consistent that she in fact has myasthenia gravis since the first time Dr. Mahajan did the blood test on it. And there is no other purpose to bring that record in other than, Your Honor, or draw the jury's attention to it, other than, and I don't believe that particular record is in evidence in this case. But at any rate, if it is, I believe that portion of it has been redacted pursuant to the motions of limine. So there is just no basis for him other than to question causation here, Your Honor.
The practice of medicine is exactly that. It's a practice. They calculate, there's multiple examinations, blood tests, does it ebb and flow?
Make it correct. I have a question for you. I mean, I've already made that determination as to causation. And so how would that record be germane on any level?
It's to examine him. What does that mean to him? How was there a negative test? There's another part in his records where he said she has a positive test, but her last test was negative. Why is that?
Well, the bottom line is this. I mean, ultimately, if causation was an issue, then your argument would have merit. But I've made that determination as a matter of law. So consequently, it becomes irrelevant at that point.
Well, I mean, and I'm not saying, well, the Mayo Clinic says she doesn't have MG. You say she does. The Mayo Clinic is, the authority and the land on this, so you're wrong. I'm not doing that
Exactly
at
what
all.
he suggested. He doesn't have to use those words to suggest that, Your Honor. He's
No,
questioning
but this-
causation.
Yeah, I get it, but I mean, this is a really simple and straightforward issue. I mean, once the determination is made, then the records as far as the findings are concerned are really germane, and they're not relevant. Right? I mean, because for what other purpose would it come in?
Well, what is his, it's his own records from, that he wrote, the record from his office. And it said, and it's just, it's a one sentence that says, you know, you've tested positive in the past, this is a negative test. What does that mean? It doesn't say you don't have MG, but I'm wondering, why are there different
Why
results?
is it relevant? Because I made a causation determination at this point.
That's why I'm asking, I don't know, does
No,
MG wane, you know, come and go, or is it?
No. I've made a causation determination as a matter of law, right, based upon the current status of the evidence. I
All right.
mean, you can, it's early on in the treatment regimen and the executive patient, you can have some findings that potentially are inconsistent, but as the patient's symptoms and treatment progresses, it becomes more definitive. But my point is this, I made a determination, how long ago was that?
Month ago.
10/25, Your Honor.
Okay, so it's been over close to a month. That decision's been made. And so what that would do is that would see this, some sort of doubt in the eyes of the jury. And if I've made a determination that there's medical causation in this case, to a reasonable degree of medical probability, without any independent alternative causation and all those types of things, it doesn't come in.
I wasn't intending to go on causation, more of just trying to understand the extent and severity of her MG, but
Well,
I
you're
understand.
asking
your-
that question, the extent and severity, but as far as the record's concerned, I stand by my limiting ruling, and that issue's not relevant because it's already been determined as a matter of law in this case.
Thank you, Your Honor.
Oh, you're welcome, sir.
I try to micromanage you.
Do we just have the doctor take a stand?
Yes, thank you, Mr.
Is it the anteroom?
I was looking for a blue one, yeah, I'll read it. Something to show up. Something to show up. I love these ones. Something to show up there on the board.
Stipulated by council, I do.
Red shows up.
I ordered it. It's in the records.
It's not, not yet, unless you want to do it right now.
Right now, I ordered it. I thought I ordered it before I left.
No, because we were already asked for it.
Your Honor, shall I get
So-
the jury?
Oh, wait a minute.
It's just admitted.
So formally, exhibit number 1204 can be left in the courtroom unsupervised
Yes.
and unlocked.
Right there behind you.
Okay,
It'll be
thank
in the
you.
locked courtroom.
Thank you.
Thank you, Judge.
Your Honor, may I get the jury?
She's got it.
Oh, see? Tag team.
There's so many things that I have to email them right now,
I
just to
understand.
cover myself.
He knows what the judge says. The judge says, when he says it's entered, it's entered. And if they have a problem, it's gonna go. It has to be a little bit more flexible.
I want you to get things. Oh, yeah, yeah. Not ever.
25 out of 28.
Exactly. We'll keep going.
Because at the ultimate end of the day, the clerk's office is
Okay, I'm letting them know, just to cover myself.
Your Honor, if I need help with that, will you help us out too?
Oh,
I
yeah.
like that kind of authority.
Right.
We tried to work on things. All right, so jury.
Next time you need help, I'll.
Yeah.
Please be seated.
All right, do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
Okay, thank you, gentlemen. It's my understanding we're going to continue on, is that correct?
That's correct. Thank you, Your Honor. Good afternoon again, ladies and gentlemen. Good afternoon, Dr. Mahajan. Dr. Mahajan, could you discuss with us and explain why it takes 3 hours to do a IV infusion, this IVIG? What is the reasons behind it?
So IVIG is very viscous. It's actually very, very thick. And so we do a very, very slow drip so as to make it more comfortable. It's not a comfortable situation. And as you get it, it really takes a toll on the body. So we really want to space it out to make it more tolerable for the patients. Often rooms are set up with, like lazy boys, anything to kind of keep the patient comfortable because it's not a very pleasant experience, unfortunately.
And doctor, are you aware that Aristotle Onassis, Jackie Onassis' husband, died of myasthenia gravis?
Yes.
Are you aware that Sir Lawrence Olivier, excuse me, died of myasthenia gravis?
Yes.
And there's been a number of famous people who've died of this disease, right?
Yes.
Now, at any time over the past 4 years, since Lisa filed her lawsuit against Real Water, did the Real Water lawyers attempt to take your deposition in order to ask you questions under oath about your diagnosis, treatment, and recommendations for future treatment of Lisa?
No.
Okay. Did Real Water's lawyers ever take your deposition at any time?
No.
Did you understand they had the right to take your deposition and could have if they chose to?
Yes.
Okay. If they would have taken your deposition, would you have told them what you have told this jury under oath today about your diagnosis, treatment, and recommendations for further treatment for Lisa?
Yes, I would have.
Okay. Brendan, can you please bring up Exhibit 1011, page 45, please? When was the next time Lisa had IVIG treatment on an outpatient basis at your office, doctor?
That was on November 13th, 2023.
And what brought her back?
She started having worsening symptoms. Weakness in the legs, she was being tired, and the fullness in the throat.
Okay. And did you do that at your office instead of the hospital?
Yes, so the concern was we were hoping to keep her out of the hospital, so preemptively we were able to get IVIG on board for her to hopefully keep her stable and prevent one of these crises from occurring.
Doctor, in your opinion, does Lisa do better on monthly IVI treatments rather than waiting until she has a exacerbation or flare-up?
Yes, definitely.
And why is that?
Well, because it decreases the risk of an exacerbation. If you're getting treated more regularly, it helps control the symptoms and prevents these flares from happening.
Okay. And as things progress over time, is it just not worth waiting for a...
No, and when a patient has progressive symptoms over years, like Lisa has, reach a point where it's safer to get this IVIG treatment because it becomes too much of a threat to your
What kind
life.
of threat?
You can stop breathing, respiratory-wise. You can end up dying if you don't get the proper treatment on a regular basis.
Is she at the stage now where she can't risk her not getting to the hospital in time because she could die? And is that one of the reasons you're recommending the monthly?
Yes, that's my professional opinion, yes.
Okay. And you mentioned earlier, this is a chronic disease.
It is.
Is it going to get better or is it going to get worse or going to stay the same?
Typically, these situations progress over time, meaning they get worse. And so the sooner we are able to, manage with the IVIG, the less the risk of threat down the road.
So did there come a time when you insisted that Lisa have monthly IVIG treatments?
Yes,
Okay, and when was that?
that was as recently as February 25th,
Was that February 27th?
or 27th, excuse me, 2025.
Brendan, please bring up Exhibit 1039, page 2031. What happened in 2025 that caused you to recommend monthly IVIG treatment? Well, first of all, is this recommendation for the rest of her life?
It is, yes. I think she's going to need it moving forward.
All right. And so what happened in 2025 that caused you to recommend monthly IVI treatments for the remainder of Lisa's life?
So she's gotten to the point where I feel like the symptoms are progressive to, she ended up in the hospital. She had symptoms for probably 3 weeks beforehand, fullness in the throat, started having really bad weakness in her legs, and then her neck muscles started getting affected. And that's when I started worrying about her throat closing up. So we ended up sending her to the hospital.
And when was she admitted to the hospital?
She was admitted on 2/14/2025.
And how long was she having these progressively worsening symptoms prior to that, to the point where you needed to do this?
Approximately 2 weeks.
Okay. And what symptoms was she experiencing?
Well, it started with the legs. The leg weakness progressed to involve muscles in the neck. She started having some weakness in her head and neck as well.
Okay. Brendan, could you bring up Exhibit 1039, pages 2062? And did they give IVIG treatment to Lisa during this hospitalization?
They did.
And how much did they give?
They did 3 days of IVIG.
So that was 3 rounds?
3 rounds. Yes, sir.
One each day?
One each day.
Okay. You mentioned earlier that Lisa has issues with veins when getting IVI treatment. Is that correct?
That's correct.
You said, I think you used the term, she's a hard stick.
That's correct.
Okay. What is the solution for these problems now that she's going to be going on IVIG treatment monthly?
She'd require a permanent cath called a portate cath.
Is this what you're talking about right here?
Yes, that's correct.
Okay, and that's placed over one of her breasts?
It is.
Okay. And is it your intention to have that inserted?
Yes, it is.
Okay. And is it a permanent port?
It is a permanent port, but it has to be replaced every 5 years.
Every 5 years?
Yes, sir.
Okay. Is there a risk that it would have to be replaced more than that if there's an infection or something?
Yes, there's always risk with any line you place. There's always risk for infection. So it's something that has to be watched closely, cared for closely, and it requires more maintenance. But it will allow access for her treatment, which I think is imperative.
Did you see Lisa following her discharge from the hospital?
I did.
Okay, and did you follow up? You have a follow-up appointment on her. I think you said it was February 27th.
Yes.
This year. Okay. And has your treatment plan changed based on her recent exacerbation?
Yes. I feel she's to the point now that she's going to need the IVIG on a monthly basis.
I'm sorry, what?
She's going to need the IVIG on a monthly basis.
Okay. And is that 1 day a month? We're doing 2 rounds?
So she'll have to do 2 consecutive days, 1 round each every month.
Well, why are you changing to?
So the issue we ran into when we were doing the 2 days, or 2 consecutive treatments in 1 day, is we would experience a lot of migraine headaches. Obviously, it takes a larger toll on the body. At this juncture, once we get the portate cath placed, she's able to do 1 day at a time, twice a month.
Okay.
Infusion per day, twice a month.
Any other reasons why your treatment recommendation has changed to monthly again for IVIG?
So it's just the threat of not being treated. I mean, at some point we reach risk versus benefits, and I think, we definitely don't want to risk her losing her life, not being able to breathe.
Did I provide you some documents? My office provided you some documents this morning that included a motion and a declaration in this
Yes.
case? Okay. Did you have a chance to review those documents?
I did.
Okay. Was one of the documents titled Plaintiff Lisa King's Trial Brief Regarding Plaintiff's Right to Present Ongoing Medical Treatment and Future Recommendations?
Yes.
Okay. Was there an indication on the top right-hand corner of that document as to the date it was electronically filed?
Yes.
What is that date?
March 2nd, 2025.
Was that this past Sunday?
Yes.
Okay. And the last page of the document, do you see, you have them in front of you?
Yes.
Do you see a title that says Certificate of Service?
Yes, I do.
And does that certificate of service document that it was served on those persons designated by the parties in the e-service master list for the above referenced matter in the 8th Judicial District Court e-filing system in accordance with mandatory electronic service requirements of Administrative Order 414-2 and the Nevada Electronic Filing and Conversion Rules?
Yes.
Okay. And is this document signed by an employee in my firm?
Yes, it is.
Does it indicate this was served on Sunday, March 2nd, 2025?
Yes, it does.
Your Honor, I would ask the court to take judicial notice that the counsel for real water is included in those persons designated by the parties in the e-service master list for above referenced matter in the 8th Judicial District Court e-filing system in accordance with the mandatory electronic service requirements of Administrative Order 14-7 and the Nevada Electronic Filing and Conversion Rules.
Is there an issue there?
No objection.
Okay, just want to make sure.
Now, on page...
I'll take judicial notice.
Thank you, Your Honor. On page 3 of the document, not the declaration, does it say, quote, on Thursday, February 27th, 2025, Ms. King had a follow-up appointment with her treating neurologist, Dr. Mahajan?
Yes.
Does the document also say that later during that same day, February 27th, 2025, the undersigned was informed that Dr. Mahajan had decided to change the frequency of Lisa King's IVIG treatments in order to better control her symptoms?
Yes.
Who is the undersigned on the document?
You are, Mr. Eglin.
I am. And does the document also say the undersigned immediately arranged for a telephone conference with Dr. Mahajan for 7 a.m. on Friday, February 28th, 2025?
Yes.
Okay. Does it also say during this telephone conference with Dr. Mahajan, Dr. Mahajan confirmed that he was placing Ms. King on a monthly IVI treatment schedule for Ms. King to better control her symptoms?
Yes.
Does it also say following the phone conference with Dr. Mahajan, the undersigned contacted Lisa King's expert life care planner, Bruce Hirschfeld, MD, and asked him to confirm this with Dr. Mahajan?
Yes.
And did Dr. Hirschfeld confirm this with you?
Yes, he did.
Okay. Does it also say that the undersigned, office immediately requested the medical records from Dr. Mahajan's office for the February 27th, 2005 visit?
Yes.
Does the document also say then, however, the record received did not indicate the change to regular monthly IVIG treatments? It was not authored by Dr. Mahajan, but rather Andrew Violin, APNP.
That's correct.
Did you see in the declaration signed by me, the affidavit, that I was confused by that?
Yes.
Why it wasn't in the record? Okay. Does the document go on to say that the undersigned then met with Ms. King's expert life care planner, Dr. Hirschfeld, at the undersigned's office at 3 p.m. on March 1st, 2025?
Yes.
That would have been last Saturday, is that right?
Correct.
Okay. Does it then say that during this meeting, the undersigned learned that Dr. Mahajan saw Ms. King after his APNP saw her on Thursday morning, February 27, 2025, and informed Ms. King of his change in her future treatment plan?
That's correct.
Does it then say that based on this recent treatment and updated treatment plan, it is anticipated that Ms. King's retained expert witness, Bruce Hirschfeld, MD, and Stan Smith, PhD, will supplement their reports accordingly?
Yes.
And you agree there was a declaration signed by me attached to this motion?
Yes.
Signed under oath?
Yes.
And you've had a chance to review that?
I have.
Okay. At the top right-hand corner of this document, does it indicate the date it was electronically filed?
This one was 3-2?
Yeah, just may I approach your own?
Sorry.
Yes.
Yeah, sorry, it was 3/2/2025.
I'm sorry. We'll let the juror pick up her notebook, or his notebook. Or he's just being a gentleman. Okay, again, what is the date that indicated is filed?
3/2/2025.
So March 2nd, 2025, which would have been Sunday.
Yes, sir.
Okay? In the declaration, does it set forth the same information that was contained in the motion we just went through?
Oh, as far as,
In the declaration you reviewed,
yeah,
does it basically contain the same factual information that's contained in the motion we went through? Is that a yes?
yes, sir.
Okay. And in the declaration, on page 3, paragraph 7, does it state, quote, after receiving the medical record, I did not see in the record where Dr. Mahajan had indicated the change for IVIG treatment from when Lisa had a flare-up to regular monthly treatments. However, I did see that the provider listed on the record was Andrew Violin, APN, and not Dr. Mahajan.
Correct.
Yes?
Yes, sir.
Okay. And in paragraph 8 of that document, does it then say that I met with Lisa's expert life care planner, Dr. Hirschfeld, at my office at 3 p.m. on Sunday or Saturday, March 1st, 2025?
Yes.
And does it go on to say, I was still confused by the medical record not reflecting the change in Dr. Mahajan's future treatment?
Yes.
Does it then say, however, I learned in the meeting with Dr. Hirschfeld that Dr. Mahajan saw Lisa after the APNP saw her on Thursday morning, February 27th, 2025, and informed Lisa of his change in her future treatment plan?
Yes.
Does the declaration then go on to state in paragraph 10 that on Sunday afternoon, March 2nd, 2025, I prepared this motion to notify the court and opposing counsel of what had been learned, and that Dr. Hirschfeld and Dr. Smith would be updating the respective reports regarding Lisa King?
Yes, it does.
Now, just for your reference, I gave my opening statement in this case 2 days ago on Tuesday, March 4th in the afternoon.
Yes.
Okay?
Objection, Your Honor, may we approach?
Yes.
I think you do.
And counsel, thank you.
Thank you, Your Honor. Now, I thought we were going to wait on this.
Yes, Your Honor, we can do that. Thank you.
So back, just for your reference,
Yes.
I gave my opening statement on Tuesday afternoon, 2 days ago in this case.
Yes.
So, the documents you reviewed this morning clearly indicate the indication that the information that I did my opening statement on Tuesday, that when I gave my opening statement, that was not the first time Real Water's representatives had heard that you had updated your treatment plan for Lisa.
I agree with that statement.
Okay. And does it indicate that in fact they were notified on Sunday, March 2nd, 2025,
Yeah.
24.
Yes.
And if a
agree.
lawyer in this case stood up in front of this jury like this and said, and you know, when we first found out about this updated treatment plan for
Objection,
Lisa
Your Honor.
King,
This argument-
the same day you did.
Hold it. Tone it down.
The same day you did. Would that be true?
No.
Your Honor, my objection,
Yes,
this is argument.
okay.
He's not asking the witness.
I just asked a question to witness a whole bunch of questions.
Right.
And I just asked a question, witness, would that be true? And he said, of course,
Yeah,
no.
and you can ask it again.
Can you face the
And
witness?
would that be true
No.
by that lawyer making that statement?
No.
Doctor, do you believe that corporations and the people who speak for them in this country should tell the truth and follow the rules?
Objection, Your Honor. This,
What's the objection? I just want to make sure I
look,
understand.
this is beyond the scope of this witness here. I mean, he's a medical doctor.
Not under these circumstances, it's not.
Yeah, but I'll sustain. You can rephrase, Mr. Edwards.
That's okay, Your Honor. I think everybody's got the point. Now, another question. If a lawyer were to get up in front of this jury and infer or imply or suggest by the tone of his voice and his mannerism that there was something nefarious or untoward or manipulative about you changing your treatment plan for Lisa to monthly IVIG treatment,
Objection,
what would
Your
your
Honor.
response to that be?
Okay, hold 1 second.
We have
What's the
a
objection?
3.4 violation. He's doing the same thing. He's directing his comments to the jury.
All right.
The 3.4 violation was when Mr. Johnson gave up and lied about this to the
Wait,
jury.
hold it,
Whoa.
hold it, hold
Okay,
it,
all right.
hold it.
I need an instruction, I need to approach the bench.
Yeah. All right. Okay, ladies and gentlemen, I think this might be a good time to take a quick break. Do you agree? I know some of you do. All right, what we're going to do is I just want to remind everyone, you're admonished not to converse amongst yourselves or with anyone else on any subject matter connected with this trial, or to read, watch, or listen to any report or commentary on the trial or any persons connected with this case, or by any medium of information, including without limitations, newspaper, television, radio, social media. Remember that. And last but not least, do not form or express any opinion on any subject matter connected with the trial until the cause is finally submitted to you.
All rise for the departure of the jury.
Okay, let's continue on, and I wanted to take a break.
We have the doctor step out.
Oh, yeah, and thank you for reminding that, sir. You don't need to be here for this. And sir, you can go back to, you know where the ante room is, right? Yes. Okay. Now, it's my recollection that the defense is making a request. Boy, they made two requests for the record. I guess the first one was for a mistrial. Is that correct, sir?
That is correct, Your Honor.
And the second one was for a curative instruction?
And the alternative, Your Honor.
Yes, I understand. I do. And you can start considering, have you put anything together yet?
We're putting it together right now, Your
Yeah,
Honor.
just take your time.
Thank you. I appreciate it.
All right, Mr. Kemp.
Judge, I've been trying to get the opening statement section, but during the opening statement, Mr. Johnson, I would say it was more than implied that there was some manipulation going on with regards to the treatment that Lisa King would have to have. And he was implying that he had not known about anything, or he was saying he did not know that there was once a month treatment until, I can't remember what day he said. Well, that wasn't actually accurate, as Mr. Egger just pointed out, and for the other reason that there's a reference to that in the December, or excuse me, the 2019 medical record. So I don't think, I wouldn't use the term that was used, but clearly he greatly exaggerated his knowledge of the situation and portrayed it as such that the jury would think that this was exaggerated, made up, pretextual, in an attempt to diminish the scope of the treatment. So for that reason, I think the the foundation for this problem was really what Mr. Johnson said during the opening statement. And I have it here now, let me just read it into the record. Quote, and I don't have well, I guess I do have page number. It's page 33, Your Honor. This is Mr. Johnson, line 4. Quote, yet we believe that this number has changed. We believe that it's no longer going to have injections quarterly, but from the opening, it was stated that she's going to have these infusions twice a month, every month for the rest of her life. We learned of that when you learned of it yesterday. Clearly that wasn't accurate, Your Honor. Clearly that wasn't accurate for the 2 reasons I've indicated. They knew about it from these filings that were made on that particular Sunday. And they also should have known of it from the medical records, which in 2019 dictated once a month treatment, which she actually had once a month for 3 months, my understanding. So then he says, quote, you'll have to gauge the testimony of the experts in that regard. We'll learn it together. So that was the foundation for this whole problem when he actually misstated when he learned of it. And again, I wouldn't use the terminology that was used, but clearly the suggestion to the jury was that plaintiff was trumping up their damages. That was the clear suggestion to the jury, and that was wrong. He shouldn't have made that suggestion. And 2 wrongs don't make a right, but given the fact that the genesis of this was all theirs, there's absolutely no grounds for a mistrial. Now, with regards to a curative instruction, I don't oppose saying that counsel got, I don't know what the right word is, overheated, something, and that he didn't intend to say that Mr. Johnson was a liar, but there's a disagreement with regards to the facts, and that the jury's the ultimate one to decide the facts. I think curative in that fashion, we wouldn't object to, depending on the phraseology of it.
May I respond, Your Honor?
Oh, absolutely.
Your Honor, looking at this notation, it came very clear that at some point in time, this examination of this doctor had nothing to do with exploring the damages in this case or the facts in this case. It became some sort of bizarre, one-sided effort by Mr. Ecklet to talk about himself in some strange manner, ultimately somehow on an irrelevant issue on when he produced documents, etc. In reality, Your Honor, if you look at the opening, and incredibly confirmed by the doctor on the stand, that he wasn't always treating her once a month. He was huge gaps, 14 months, and their expert, Dr. Hudson, said that she needed quarterly IV. We learned, like everybody else over this weekend, that there's now going to be a new treatment plan. Hudson's plan is going to have to change. The experts on future damages is going to have to change. The economic expert opinions are going to have to change. And those didn't happen on that day. I don't know when those were finally disclosed. Do you know, Mr. Watson?
We don't have the economist yet, I believe. Hirschfeld's was updated, I believe, within a couple minutes of your opening starting.
So we didn't have that witness's update until my opening started. So I had no idea what I was opening to. All of this was unfolding, and as the court realizes, well, when are you going to get it to them, counsel? And that's on the record. It was going to be weeks. I thought we were supposed to get somebody's today.
You've already
Mr.
gotten.
Smith.
You've already gotten.
This one at a time, this one at a time, this one at a time. Because I have to follow the facts.
Right. So what it is, that was the issue. Of course, now that was addressed. Now Mr. Ecklet came in and opened court, and I don't know what to make of that. He's frightening people in the jury box. He's approaching them with his arms up like he's attacking them, calling me a liar. I don't even have this witness. I'm just sitting here wondering what's going on. Mr. Freeman objected numerous times that this is a Rule 3.4 violation. Over and over again. This was incredible. I'm getting admonished in this court for saying, what was it? What am I getting admonished for?
For saying it's good news.
And it's good news that they don't have any symptoms? That's what I get admonished for? And this man's charging the jury box and calling me a liar, that's a mistrial, Your Honor.
It's a 3.5D violation as well.
But that's okay.
Sorry.
So I trust the court will consider it. I've never been in this situation before. It is truly ironic that it's happened today after what's happened the last 2 days, when people who are casting aspersions and asking for $50,000 in sanctions for basically nothing. And I appreciate the court, dealing with that rationally. We'll put together something, but that's my request, Your Honor. Thank you.
I understand. Okay, Mr. Kemp.
Yeah, Judge, he basically admitted that he made a misstatement during the opening, because now he says that he learned about it over the weekend. When he was addressing the jury on Wednesday, he said, quote, "We learned of that when you learned of it yesterday." Yesterday being Tuesday 3/4, not the weekend. And, it wasn't a small mistake, because he immediately followed that up with this statement. Quote, "You'll have to gauge the testimony of the experts in that regard. We'll learn it together," unquote. So what he was suggesting is that the experts were going to fabricate their testimony, that they were making up this treatment regime that had suddenly been dropped on him. So, I think the concession here that was just made, that they did make, again, I wouldn't use the terminology that was used, but this was clearly a misstatement that was made during the opening, and it was made on purpose. It was made to question the validity of the plaintiff's damages claims in this regard. And so for that reason, since he started it, there's really no basis for mistrial. But again, you did start.
No, you're gonna get it, no.
Can I have final word, Your
Wait,
Honor?
no, you're gonna get the final word. I just want you to,
Judge, how can he say he didn't start it when this is, he just admitted he was wrong when he said this. "We learned of that when you learned of it yesterday." That is not a true statement, Your Honor. And like I said, it's not simple, it wasn't a mistake. He used it to immediately attack the expert testimony, which was the foundation of the plaintiff's damages claim. So what he's trying to suggest is that this once-a-month treatment is somehow bogus. That's what he was trying to do, okay? Just when you've created a situation that you're complaining about, you shouldn't be heard to move for a mistrial. And again, I think the curative, I've already said what I've said. I haven't heard any language coming out of them. That when they do give it to us, we can evaluate.
Your Honor,
wait. I didn't hear that last part.
What'd you say?
When they submit any language, we can take a look and evaluate. Sure.
We do it both ways on that.
Yeah.
Mr. Parker, if you look at the last, Mr. Johnson, don't worry, you're gonna get the last final word. And plus, I wanna see what they're working on when you're done, but,
Yeah, Your Honor.
wait, no, I think Mr. Parker just has one comment, that's all.
Oh, of course.
That's
Thank you. Your Honor, I always go back to the rules, Your Honor. And I appreciate what counsel said a second ago about the 3D of the Nevada Rules of Professional Conduct. 3D says that lawyers should not engage in conduct intended to disrupt the tribunal. That's not what Mr. Eglin was attempting to do. What he was trying to do, he was actually trying to address the 3.5A violation committed by Mr. Johnson. Mr. Johnson, pursuant to the rule, violated 3.5A. The rule says a lawyer shall not seek to influence a judge or juror, in this case the jury, or prospective juror or any other official by means prohibited by law. He knowingly said something to be false, and then when he's called upon it by way of a document that was admitted through judicial notice being taken, he's upset that he was called a liar. Now, like Mr. Kemp said, perhaps the word liar was strong, but it's certainly correct. He did make a misstatement on the record in an attempt to influence this jury. Now, let me say it this way. I said a misstatement or a false statement. Mr. Kemp said a liar. And like I said before, Mr. Eglin, I'm sorry.
Mr. Kemp.
Mr. Kemp said he started it. But Mr. Eglin said he was a liar. I said that wasn't a word I would probably use. Mr. Kemp said that's a word he would not use. It was a misstatement. I think we can all agree that that was a misstatement that he made in an attempt to influence this jury improperly. So let's think about it this way. if Mr. Eglett did not address it, that would have been left with that jury throughout this trial. And this was the only witness he could bring this forward with. So should he sit on his hands and not inform this jury that the statements made during opening statement, after Mr. Johnson paraded around during his opening statement saying, I think one of his first lies were the truth and nothing but the truth and all of this. And then he's caught in a misstatement.
An untruthful misstatement.
So this is the only way it could have been addressed. Again, I believe there's a concession here that it was a misstatement. I think there's a better way of dealing with it through some form of comment that perhaps Mr. Eglett was a little more overzealous, but he certainly felt, and I think rightfully so, that he was personally attacked by that opening. So that's what I would suggest, Your Honor. 3.5D was not violated. 3.5A was. I think this should be taken in, the court should be tempered by the rule. And I'm looking forward to seeing whatever curative instruction they're thinking about, but it should only address perhaps the word being said and not the intention of it.
Your Honor, if I could just address this, and Mr. Jones could, of course, have the last word on
Johnson.
this.
Johnson.
Excuse me. Your Honor, in everything that Mr. Parker said and Mr. Kemp said was right, starting with that I should not have ever used the word liar. More accurate or a more gentlemanly word would have been untrue statement, because it was an untrue statement that's been admitted, and even if it hasn't been admitted, is clearly proven by the documents that were read into the record and identified here. But I want to apologize to the court. I want to apologize to Mr. Johnson and his team for losing my temper. I hope that the judge is no excuse, but I hope the judge can understand it's not something I've ever done before. I, quite frankly, am stunned that I did that, but I was very upset about what he said in his opening statement to this jury. I absolutely felt like he was suggesting, and I believe he was, to the jury that I was somehow manipulating this doctor and causing these damages to go up. And you just can't accept that it was anything else other than that, Your Honor. But I'll sit down, and I don't have any comments about curative instruction or anything like that.
Okay. Thank you for your patience.
Thank you,
I
Your
agree.
Honor.
I agree with that. And if anyone else from the defense team wants to chime in,
I'm sorry, Your Honor.
Your Honor.
Mr. Esposito, you said no way, huh?
I'm a talkative guy, Your Honor. I apologize.
You know, Your Honor, just because I have the skin of a rhino, I don't think this is funny. I don't think the court thinks it's funny. The snickering, the juvenile antics on this is embarrassing to the legal profession. It's an embarrassment to you, I know, and this court. You know? So let's stop the joking around. Mr. Eglett doesn't get to decide what punishments are dealt out. We had a hearing on this outside of the presence of the jury, and the court entered an order. That was it. That was over. It isn't for Mr. Eglett to get up on a personal crusade and swarm the jury and frighten the jury, which I believe is on the record now, that one of these poor jurors was intimidated and frightened at Mr. Eglett's red face getting right next to theirs, calling me a liar. That is unprecedented, as far as I know. Now, it's certainly not unprecedented in a criminal context when some guy runs up and jumps over the bench. All right, I'm not comparing it that way, but it's pretty darn close. I don't think it's funny. And then to have people come in and make justifications for it. Well, he said this, and it hurt his feelings, and he started it. The record stated she has a doctor, Dr. Hudson, who's made certain opinions in an expert report dated November 2024, a short 4 months ago, in which he said she would need to have IVIG infusions that you've all heard about so much, would have to be done quarterly. That is what their doctor said, Dr. Hudson. It was at that stage that they indicated, oh, she's going to have it more. We're going to get you the numbers. We never had the numbers. The numbers weren't laid out. What we're talking about, it went from $4 million to what?
19 and change.
19 million? It went from 4 million to 19 million, Your Honor. That's what I'm talking about. That happened, and we objected to those numbers changing. Excuse me?
It was 12 million.
I thought it was high. $12 million, right? That's what we were having to deal with, and that's what I had to address. But somehow I ended up getting a reprimand for this, and we moved on.
But I didn't give you a reprimand for,
Well, curative instruction, Your Honor. But
Yeah.
I sure didn't call anyone a liar.
You did a curative instruction for that.
yeah, no, the curative instruction was for, I mean, I have it right here in front of me.
I did, Your Honor. It was all during that period of time.
It wasn't.
And I didn't scare any jurors and create a mistrial situation with my actions about myself. Did I not, Your Honor? Anything that I did in this case was advocating for my client, what I felt to be, and my ethical parameters and my duty to my client. It never turned into something about me. No one cares about me in this case. I'm a vessel. Mr. Egler turned it into a case about him and was yelling at the top of his lungs. And they were claiming I was making jury arguments during opening statement. It's truly an irony. So again, I state that we need to have a mistrial entered. I know it makes everyone sick to their stomach. It makes me sick to my stomach. That's what I asked. If the court doesn't agree, I'll work with my team. I'll get some language for you, see if the court agrees, and we can take it from there, Your Honor, but I need about 10 minutes.
Your Honor, I have some
address
language. Let's not address it.
No, but it's-
Your Honor, I have some curative language that I just offer to counsel, and they can do with it what they want. Mr. Eglett used the term, quote, liar, unquote. He has apologized to the court and to Mr. Johnson, and Mr. Eglett should not have used this term as an officer of the court. You are instructed that this term liar is stricken from the record.
That's not gonna work, Your Honor.
Well,
I'm gonna give you a
let's
chance
start
to,
somewhere.
I'm gonna give you a chance to formulate whatever it is.
Thank you, Your Honor.
And anyway, I mean, I thought about it, and I think this is kind of overlooked in the whole process. And as far as, and I'll tell you why I ruled the way I ruled. Ultimately, when it dealt specifically with the myasthenia gravis, is this. That's a progressive disease. And it's what I find really fascinating about it is it was kind of like a big deal back in the 60s and 70s, and you don't hear about it as much today. But it was almost akin to like Lou Gehrig's disease and the whole, and a lot of diseases at the time that would get progressively worse. And this one fits in that, I guess, area of, unfortunately, people get certain diseases and they just don't get better. They just don't, and I understood the medicine behind this, so I wasn't surprised by that. Getting back to this issue, there's no question that what we had happened was unfortunate. There's no question about it. My big concern right now is how to get this case back on track. That's a concern I have. They have a suggestion. I'm going to give the defense team an opportunity to continue writing whatever recommendation they might have for a curative instruction, and I'll read that, and then I'll take a look and see what it has, what it says, and then I'll make a decision like I always have to. But and the thing to remember about this case, and this happens to be, I guess, the 5th case that's gone to trial right now involving primarily the same defendant. This is my 3rd, and that's probably why I know a lot about the case factually, because I've heard it 2 times. I guess our last trial was in what, October?
Yes.
October, right? Mm-hmm. And so it's 4:12 right now. When you're ready, I'm ready. I'm gonna step down for a few moments.
Your Honor, I don't know if you want to release the jury now.
Wait, we got a witness, so.
Yeah, we do. I just want to give you a chance to do what you have to do.
And,
Yeah, you can use the ante room if you want to, just quickly, and get something done. Yeah, go ahead.
Earlier when, Mr. Eglett, when you were up there putting on exhibits, I believe you said exhibit 248, but that was not addressed in, when we were going over our numbers. What's that?
There shouldn't be a 248. Is the number even a page?
So I don't know if I
Is
missed,
that a page number, or that might have been a page number?
it was between exhibit, 1039 and 1011. It may have been a page number and I misunderstood.
There was a 383 page number. What did you say the number was?
248.
There you go. It's a 299 page number, a 302 page number.
It was between which two exhibits?
1039 and 1011.
There was a 648 page number between 1039 and 1011. It was
So maybe
a
that
page
is-
648 on the 1039.
Okay, and you were just talking about a page number, not an exhibit?
Yes.
Okay. Thank you.
Is that taken care of?
Yes.
Thanks, Rick.
Around the record.
Have we prepared what's necessary? Let's go ahead and note our appearances.
Your Honor, Will Kemp for plaintiffs.
Teddy Parker, plaintiff, Your Honor.
Robert Hagan, plaintiff, Your Honor.
Maggie Federico for plaintiffs. Brianna Smith for plaintiffs.
Eric Peppermint for plaintiffs.
Brad Johnson, Eric Freeman, Tyler Watson, and Michael Esposito for the defendant.
Have we circulated the language?
Right now, Your Honor. Sorry, I was trying to find one email address.
And do you have a printer here, or do you?
No, I haven't seen what.
We have one? Yeah. We have one, Your Honor.
Just send out.
Oh, you know what? Hold on. Will, you edge on this.
We need to get going quickly.
Yeah, we gotta get this witness going, Your Honor. I don't have much left, but I don't
Okay.
know if he's gonna be able, I don't think he's gonna be able to come back tomorrow. So we have to bring him
I understand.
time.
Couple of points. I want to see the instruction. As far as the request for a $50,000 sanction, I'm going to deny that. And I'm not going to grant a mistrial. I want to see the instruction.
Thank you,
See
Your
what you
Honor.
have. And can you, your printer, just get it going so we don't have to wait for that. Sorry, can you give me your email?
I gave them my email.
No, I sent it to Robin so you can send it for I can send it directly.
You can send it to me and I'll print it.
And then this is supposed to go before you set that up.
We are, wait, you are distributing comments in their entirety? My comments in my entirety? Okay, I got it. Yeah, that's, no. First part, okay. Just go with yours, man.
I think yours is right. I think yours was good.
Yeah, Judge, I don't know if you have theirs.
I have not seen it yet.
Of course, you have it in a second.
I just got it.
Yeah, I don't know, you're right. You're right.
I'm printing it.
And he will make a personal charge to you. I don't want to say, I want to do that on my own. Okay.
Just use yours. Yours was good. You can have my color when you want to.
Thank you.
They didn't pay that. I'm paying $10,000.
Okay, done.
Don't do that. Don't do that.
Okay, we're back to the taser.
Go with yours. And the taser.
Taser.
That's a good question.
Yeah, Judge, do you have their proposed?
I do.
Okay. Yeah, Judge, the first thing I really don't like about theirs is the very last one, you're disregarding Mr. Hagan's comments in the entire review and make a personal apology. I think the number one thing we got to think about is we can't be prejudicing his client. Okay, so none of this can be prejudicial to Mrs. King. And if you take a look at their first two sentences, it's pretty much what I said, a little simpler. Okay, I mean, I think I really prefer my language, but what I really disagree with is their last one.
See, one of the things I was doing when I was looking at this, and that's why I wanted to see it, I wanted to have it somewhat similar to curative instruction number 2 that I gave in this case. And the reason why I say that is this. If you take a look at curative instruction number 2 that I gave, it's, I don't want to take out a highlighter on what anybody specifically did. And if you take a look at curative instruction number 2, it starts out, it says, ladies and gentlemen, the purpose of opening statement is to discuss the evidence that will be presented. I was thinking we could have the purpose of direct examination is, and then when I said here, Mr. Johnson violated our rules, I don't give any in particular as far as what specific rule, because clearly under the facts of this case, it's not proper to make arguments in front of a jury calling co-counsel a liar. I get that. And so I was hoping, put it this way, that we can have them kind of similar as far as, because I want to make sure, because we have in here Nevada rules, professional conduct, we could have put that in the other one and we didn't do that.
Right.
You see where I'm going on it?
Yeah, Judge, and I think that's what I tried to do in mine, because if you remember when we talked about the other proposed curative, we did discuss whether or not to put professional conduct references in there, and we didn't do that. So I think, we should do the same thing here we did there. So I think mine is really appropriate.
Let me hear from, go ahead, I'm listening.
We would need the language to be stronger regarding the conduct, because it was not simply limited to calling Mr. Johnson a liar, but it was the intimidation that the jurors felt, getting close to the jury box, yelling at them, including the disparaging comments. We would request that language be included as well, Your Honor, because the jury was uncomfortable. They complained to Your Honor about what they experienced, and that needs to be addressed.
Judge, one juror was uncomfortable, the one that was closest to Mr. Egler, who I believe is Mrs. Erickson. But I don't think we need to single that out. And I mean, attorneys all the time, and I've done this, you get too close to the jury, you make them uncomfortable. That's just bad technique. That's not a violation of professionalism.
I think, Your Honor, one other thing, just because of what what Tyler just said. The first person to approach that jury box in that fashion was Mr. Johnson. I didn't do it during my opening.
Okay, I understand, but I'm trying
not that this is a mimic of.
I just want to get.
Kind of thing,
I mean, we don't need to go into.
I don't think that's a violation of the rules.
Let's not go tit for tat.
Yeah, that's my point. I'm trying to get this done.
Judge, to be perfectly consistent, I suggested $1,000 donation to legal aid for Mr. Johnson. I will suggest that again for Mr. Egler, even though it's.
Your Honor, I don't pay $10,000 to legal aid.
Yeah, I mean, I'm not going there. I just want to get this. We can do it.
Your Honor, they just don't get it. It's not calling an officer of the court a liar is enough. That's what he did wrong. That has to be set forth. Everybody in this courtroom knows what he did was wrong.
I'm not saying that's not putting, I'm just trying to, I mean, if you want me to write it, we're done, but I'd like to have your input.
We've given our input.
We'd like you to write it, Judge.
And I don't know who we are, but we have given you what we believe would be the proper instruction, Your Honor. We have different versions?
If I may. So, Your Honor, what I did is I took your.
Can you print, no, just print it and send it to me.
Okay.
That's quicker. That's actually.
Yeah, I was
quick.
just gonna say, I put it side by side with curative instruction number 2 and tried to mimic to the best of my ability.
Did you send that to us, please?
I'm trying to, hold on.
Okay.
I'm just gonna,
And Mr. Esposito, thank you for doing that, sir.
I removed all references to rules of professional conduct, and I
Yeah.
tracked, you'll see. And if it's
Yeah.
not what your honor wanted, let me know, we can tweak it.
That's okay. I appreciate the effort though, sir.
Let's see here.
It's in both sides.
Mr. Campbell, I don't think I got your email on the last one.
No, just send it to Brianna. She's got her computer here.
Let's see.
Okay. There we go.
Okay. Everybody should have that in a few seconds.
Thanks, Mike. All right, let me see.
Thank you.
It's there.
Right?
It's there.
Thank you, man.
Your honor, I assume you have the language from.
I just got it.
Yeah, Judge, I think this goes a little too far. It starts bringing in justice of the cause and other things, and it's repetitive in terms of admonishments. So I think probably the best thing to do would be just to have you draft something using ours as a basis and this last one as a basis.
So your honor, this tracks the language of your prior one. It starts.
No, it
off-
does. I know it does. I'm just trying to look at it. I'm just saying.
Sorry, I don't mean to interrupt, your honor.
And that's okay.
Yeah, Judge, what I really don't like about it is as to the justice of a cause, and then the additional part about stepping up to the jury box, yelling, disparaging, you know. I think if they just focus on what they brought up at the bench, which is calling a liar, yeah. I mean, I don't mind the first sentence, okay? And I don't mind the second one, is if we put a period after personal opinion. And I think the third sentence isn't necessary. We can pick right up with Mr. Egbert violated the rules, including violated the rules with his conduct, disparaging opposing counsel. And then pick it up with disparagement was improper, and you are to disregard Mr. Egbert's comment regarding Mr. Johnson, which is pretty much what I wrote in a different form.
Your honor, it's absolutely improper to give a curative instruction to the jury that does not address Mr. Eglett charging the jury box.
Your Honor,
I mean, we can look at Mr. Eglett's own video.
box. I did the same
Yeah.
thing he did in his opening
Yeah.
statement.
His hands were raised above his head, his face was bright red,
But
and he scared the jury.
here's
That's what
the
your-
thing.
that's what your
Everyone
partner
has to
did.
understand this. This is a curative instruction. It's going to be general in nature. That's how the first one was. And you did a good job in mirroring the first one. I just want to make sure.
Yes, Your Honor. I would just like, I think the jury should be afforded something that addresses the conduct that was directed towards them and not just calling Mr. Johnson a liar.
Well, Your Honor,
But see, here's the point though. And as far as Mr. Johnson and what he did, let me see here. I just want to. And here's my point. I don't think I really set forth anything in his statement regarding whether he was charging the jury box or raising his hands or.
No, Your Honor.
You did
Counsel,
state
I-
the specific basis upon which he violated the rules, which is why we included the statement to mirror that by giving the specific conduct that violated the rules. That is 1-for-1 to curative instruction 2 to curative instruction 3.
Your Honor, I concede that I was louder than Mr. Johnson, but how I placed my hands on the bar and then raised my hands over my head, I was mimicking exactly what he was doing in his opening statement when he made these comments about this is the first, when we learned about this, the same time you do. It's exactly what he did. We can bring in a video of it.
Yeah, Judge, it's bad technique, okay, but it's not a violation of professional conduct.
Right. Okay. Okay, this is what I'm gonna do. I'm gonna make it shorter and simpler. I want to just compare it to the number 2 first. And I just want to make sure I'm clear, when I review curative instruction number 2, there's no description of what happened as it pertains to Mr. Johnson physically in court. There's nothing there, is there?
Respectfully, Your Honor, that wasn't the point of that curative instruction. I think what Your Honor did is identify what the court believed to be the improper conduct. I think it merits noting that the court did not admonish Mr. Johnson for approaching the jury box at that time because the court didn't think the way he did it was improper. Context matters.
Wait, no, but context, wait. Here's my point. I'm not going to rewrite it, but Mr. Ecklet was actually doing an examination by the jury box, and that's where his lectern is set up.
And nobody took issue with where he set up, Your Honor. It was when he flipped around and started yelling at the jury.
Judge, he wasn't yelling at the jury.
I was here. I saw it.
Anyway.
He was doing a pathetic
Your Honor.
imitation of Mr. Johnson's what he was doing.
We want to move this on. This isn't about me, it's about the jury.
I
The
understand.
point is, and I understand it, Your Honor, it's the juror who said that about Mr. Egglet. I don't know what, these people, I must live in their minds, they gotta pay me rent. The point is, the juror said it about Mr. Egglet. We don't have anything more to add, Your Honor. I don't want to be a part of the spectacle anymore. I'm ready to move on.
I understand.
Judge, whatever you want to do, we're fine with it.
I'm fine. I get that. I just want to get it right. Because, I mean, for example, I'm not going to put in the curative instruction the impressions of the jury, because we don't know what the impressions of the jury are until I sit down and question them, and I'm not going to do that.
What do you mean we should do, Your Honor?
Yeah, I mean, I'm not going to do that. I can't do that, right? Anyway, I'm going to change it this way. Ladies and gentlemen, the purpose of direct examination is to obtain testimony from a witness. A lawyer is not permitted to make statements that state a personal opinion as to the justness of a cause.
I didn't state a personal opinion, the justice of the cause.
Let's hear the whole thing first.
Well, I mean, ultimately, Mr. Eglett, you did.
I called, nothing, the only
Let's hear the
thing,
first
other than their argument about me charging the jury box, but it was a poor imitation of Mr. Johnson. But what I did was call him a liar in open court. That's the only violation, Your Honor.
I'd like to hear your order without an interruption.
I'm going to finish it, and we're getting comments. Mr. Eglett violated the rules with his conduct. Mr. Eglett, by calling, let me make sure, Mr. Eglett violated the rules with his conduct by calling Mr. Johnson a liar.
That's the accurate statement.
Yeah.
That's fine, Your Honor.
That's fine, Your Honor.
Wait, let me finish. Mr. Johnson is an officer of the court. The disparagement of him was improper. You are to disregard Mr. Eglett's comments regarding Mr. Johnson.
Well, comments about calling him a liar, right?
I don't know why we're even listening to them anymore. If that's what the court would like to issue, we've given our hope for the instruction. The court doesn't disagree. I respect the court's opinion. I'm ready to move on.
Yeah, Judge, we're fine with your modification.
Just want to make sure. I'm reading it one more time. Now, I want to make sure I understand, because I want to make sure I'm clear. The issue regarding justice of the cause, of a cause.
Yeah, Judge, that's what I didn't like, because it kind of drags Mrs. King into it. You know, it kind of suggests that her cause is not just, you know, or is just. You know, that's what I didn't like about it.
Your Honor.
The violation was calling
No,
him a
I
liar.
got it.
That's it.
I asked the question, Mr. Eglett.
Your Honor, in the Gunderson case, they specifically looked at this rule, and part of the determination was whether or not they were attacking a moral component that otherwise didn't go to the the actual merits of the case. Here, what they're doing is trying to put in the minds of the jury that Mr. Johnson is somehow trying to improperly influence him, or worse yet, violating his own rules of professional conduct. Now, Gunderson was in the context of a criminal matter, but I think the rule stands.
No,
He
Gunderson
was
was
trying to properly influence them. He was.
But Gunderson was
Records document.
wasn't that a construction defect case, Gunderson, in front of Judge Johnson?
I can pull the case, Your Honor.
I think there's a couple of those.
Yeah, you think it Gunderson in front of Judge Cherry? Not Judge
Okay.
Cherry,
Yeah,
Judge-
that's a different case,
That's a
Your Honor.
different case.
But point being, what this particular case did was speak to the fact that when counsel improperly elicits some kind of attack on the morality of the justice of the cause, what they're doing is saying that there's some reason to disparage either the suit or a party or counsel for something other than the merits of the case. In this particular case, that's exactly what, Mr. Eglett, I'm still talking, I understand.
I'm just
you tried a
standing
lot
up,
of cases
counsel.
here, but I
Talk
One
to
at
the
a time.
judge, don't talk to
Well,
me.
Wait. Okay, I got it.
Anyhow, Your Honor, that's what the case law says about 3.4, to the extent the court was asking.
I understand.
Tuesday, Thursday.
Yes, sir.
Move on back to Monday. This Monday.
They were asking if I can get them on Thursday, Friday, that's what I was thinking, Thursday.
For Hudson?
Yeah.
Yeah, I think we'll do Thursday because of the spillover potential.
right, here we go. This is what I'm gonna do. Slight change, because I understand the distinction as far as the application of justice of the cause. Ladies and gentlemen, the purpose of direct examination is to obtain testimony from the witness. A lawyer is not permitted to state a personal opinion as to the conduct of adverse counsel during direct examination. Mr. Eglett violated the rules with his conduct. Mr. Johnson is an officer of court. The disparagement of him was improper. You are to disregard Mr. Eglett's comments regarding Mr. Johnson.
That's fine, that's your honor.
Thank you, Your Honor.
All right, there we go.
Judge, are we gonna finish the day when you read that to us?
How much more time do you have? And
10 minutes, Your Honor.
and then we'll turn it over.
Yeah, I'll have less than 5.
We'll get done today.
Okay, thank you, Your Honor.
Can you type it? Let me read it, because we don't have time, I don't think. I would love for you to type it. Bring him.
Robert, I think I might take
Unless you can do it like in 30 seconds.
I gotta be diplomatic here, right?
And there'll be no requirement to give any donations.
Any what, Your Honor?
No donations required.
I'm not on the board of directors of legal aid. I don't want you to think I am. But Mr. Jones and Ms. Cavea of our office are, so.
I understand. We're just gonna try to move this on and ultimately bring it home, and then the reviewing court can decide what's appropriate.
Your Honor, you're right. It was construction. Justice Douglas issued the opinion. And it was Judge Corey. That's right.
I do read these cases.
Yep. That's right. That's exactly right.
Been a while, but I remember the case.
Yep.
All right.
Should we bring the document back in here?
Yes, you can. Mr. Pepperman, you can bring it the document. Yeah, I like this.
Please see it.
All right, do the parties stipulate to the presence of the jury?
Yes, Your Honor. Yes, Your Honor.
All right. Okay, ladies and gentlemen, I'm going to issue another curative instruction for you, and I'll read it to you right now. Ladies and gentlemen, the purpose of direct examination is to obtain testimony from the witness. A lawyer is not permitted to make or state a personal opinion as to the conduct of adverse counsel during direct examination. Mr. Eglett violated the rules with his conduct. Mr. Johnson is an officer of the court. The disparagement was improper. You are to disregard Mr. Eglett's comments regarding Mr. Johnson. Right. There you go, man. And we're going to continue on. Is that correct, Mr. Eglett?
Thank you. Okay, ladies and gentlemen, I want to personally apologize to you for calling
Your
us.
Honor, we're ready to move on.
Yeah, he can make the apology
Big
personally.
apology. Personally apologize to you for calling Mr. Johnson a liar. I apologize to Mr. Johnson. I'll do it now in open court. That was wrong. I got carried away and I lost my temper, and I apologize. And Ms. Garcia, if I frightened you at all, I am very, very sorry. That certainly wasn't intentional. Okay, let's see if I can get you finished up here, Doctor. Sure. Doctor, before you made the decision and told Lisa that she was going to need to go on monthly IVI treatment for the remainder of her life, have you ever met or talked to me before?
No.
Have you ever exchanged or received any texts or emails from me?
Never.
Did you even know I was Lisa's lawyer?
I did not.
Had you ever met or talked or with email or text with any other lawyer in my office?
No.
Had you ever met, talked with, emailed or text with any staff member in my office?
I have not.
In your view, would I have had any way of knowing that you were going to change your treatment recommendations for Ms.
No.
King? Have you ever been hired by a lawyer to act as an expert witness?
No, I have not.
Did you ever work for lawyers?
No, I have not.
Is this the first time you've had to meet with a lawyer and testify at trial about one of your patients?
It is the first time.
No, thank you. Are there other treatments available for myasthenia gravis besides IVIG?
Yes, there are a number of treatments also available.
Okay. Are those other treatments available or appropriate for Lisa?
So there are immunosuppressants. There are a number of different infusions that can be administered, but for Lisa, she's not a candidate for those treatments.
Why is that?
Due to her autoimmune hepatitis.
Because of her autoimmune hepatitis?
Correct.
Okay. Can you explain to the jury why it is so important that Lisa now have 2 rounds of monthly IVIG treatment at your office instead of quarterly or waiting for a exacerbation or flare-up?
So at this point, she's been diagnosed for a number of years now. Her symptoms are progressive. She's had more and more hospital admissions over time. In order to keep her symptoms controlled and keep her out of the hospital and prevent, as we talked about, respiratory failure and potential death, my recommendation is to continue IVIG monthly moving forward.
How many total rounds of IVIG has Lisa had to date?
I believe she's had 21 rounds to date.
Have you observed any emotional distress in Lisa caused by her myasthenia gravis or her autoimmune hepatitis while you've been treating her?
I have, yes.
Can you tell the jury about that?
After her first hospital admission, we initially diagnosed her, and I think after the first hospital admission, she realized what's involved with this disease process. Obviously she's at that point, she'd had a number of physical ailments, symptoms for a long time. But I think once she got into the hospital, it became very real for her. And what a lot of people don't realize is, yes, you're going to deal with symptoms of fatigue and pressure in your throat and, being tired and weak. But the issue becomes the unknown, right? An exacerbation can happen at any time. And I think that's what really kind of put fear into her. And this is someone strong that I've taken care of for some time, known for a long time now. And she really kind of broke down and obviously, realized that this is something that's chronic and it's going to affect her for the rest of her life.
Had you ever seen her this emotional before?
Never.
Okay. Did you get the sense that it was scary for her, that she was scared?
Yes, she was definitely scared.
Okay. All right, doctor, thank you. Has all the treatment you've given Lisa and recommended for Lisa in the future been reasonable and necessary?
Yes.
Okay. And has all of the treatment you've given Lisa been customary to the neurology community in Clark County, Nevada for patients with myasthenia gravis as bad as hers?
Yes.
Okay.
It's standard of care.
And has all the future treatment you've recommended for Lisa for her myasthenia gravis, is it necessary and reasonable and customary in this community for her condition as bad as it is for myasthenia gravis?
Yes.
Okay. And have your conclusions today been more likely true than not true?
Yes.
And beyond that, are you certain about your conclusions?
I am.
Okay. Have all your conclusions also been to a reasonable degree of medical probability?
Yes.
And by that, do you mean that your conclusions are based on medical reason?
Yes, correct.
All right, thank you, Dr. Bonnar.
Thank you.
Your Honor, I pass the witness.
Thank you, sir. Cross.
Yes, thank you, Your Honor. Mind if I use your table?
No, right.
All right, in the interest of...
It's easier because it's on wheels.
Yeah. Good afternoon, Doctor.
Good afternoon.
Good afternoon again. I'll be quick so we can all get out of here. I want to start off, I'm kind of confused with the timeline, the recent timeline that was discussed here earlier.
Yes.
You saw Ms. King last Thursday?
Correct.
Okay, that was the 27th?
27th of February.
Okay.
Yes, sir.
And when did you first have contact with her counsel? Was that the next day, Friday?
I spoke to the council the following, Friday evening.
Friday evening, okay. And then did you talk to them Saturday as well?
No.
Okay. And then you, I think.
Excuse me, sorry, Friday morning. I apologize. Friday morning.
Friday morning,
Yes, sir.
okay.
Sorry.
And then you met with them on Monday?
Monday evening I met with them.
And then yesterday?
Correct.
Okay. You originally said you had meetings with them on Monday and Wednesday, and then I thought I heard there was another meeting which cleared that up was last Friday.
That was a call in the morning.
The call, okay.
Yes, that was
The
a call
meeting
in the morning.
was face-to-face in person?
Yes.
I get it now, okay. Do you know why he reviewed the legal documents with you?
That I don't know.
Okay. You didn't,
Not from a legal standpoint.
okay, I was just gonna ask, you don't have any legal training?
I don't.
You didn't contribute it and trying to put it together, or?
No.
Okay. Did he tell you that he was gonna ask you about the legal document here today?
Well, he informed me, and when I reviewed the documents, that's when I was informed about them. Yes.
Okay. And did you know why you were reviewing it?
Not from a legal standpoint,
Okay.
but I just reviewed it for accuracy.
Okay. And just something I wanted to mention first. Me and you have never met before.
No.
Okay. Just have a few questions. I'm going to call her condition MG because
Sure.
I will clearly butcher the
Absolutely.
full name. I hope that's okay with you.
Sure,
I mean, no
absolutely.
disrespect.
No.
Wanted to ask you about those IVIG infusions.
Yes.
Now, when you saw her originally in 2018, you had recommended the monthly infusions, correct?
Yes, we did.
Okay, but that's not what happened.
Correct.
Okay. Now, I know she had several of the infusions in 2019, but after that it became sporadic.
So, yes, there were gaps in her treatment.
And do you know, did she have any in 2020?
I'd have to look back. I cannot recall.
I didn't see any. In 2021 as well. Do you know if she had any in 2021?
That I don't know offhand. I have to review the dates.
All right, well, we were going through them here, and I didn't hear any there. You did mention the one in November of 2022.
Correct.
You think, how do you explain these gaps in the treatment of the infusions when you had recommended monthly?
Sure. So just to be clear, I saw her for the first time in 2019.
Yes.
And shortly after I saw her, I recommended getting, we tried the proteostigmine initially. That didn't work out for her, so we actually recommend getting IVIG. We put it in with the insurance company, but it got denied. And despite all my efforts to get it approved, we didn't get it approved in 2019. And I also ran into a problem after 2023 when she was getting it. There's a gap there because, again, the insurance company, we had difficulty getting approval for the medication.
And then, before this last, I'll call it round of infusions, which was just in the past couple weeks?
Correct.
Before that, her last infusion was in November of 2023?
That's correct.
About 14 and a half months ago? And now, did you just, the February 27th, did you change your opinions to have her get monthly infusions at that time?
I did. The reason I did that is because at the end of 2023, she started experiencing cardiac problems. She started having tachycardia. She had a lot of, she had to get a cardiac workup, and she was not stable to get the IVIG at that point. So that's why there's a gap in her treatment, because she was getting worked up by cardiology, and I didn't want to risk, obviously, it's with the infusion, there's always potential. Her blood pressure was out of control, and we cannot infuse a patient like that. So during that course, she was getting worked up by cardiology, wanted to make sure everything is stable, and then she had this exacerbation. And for that reason, the cardiac workup was clear, everything was good, and that's the decision I made at most recently when I saw her, based on that.
Is there a possibility that although you recommended monthly infusions again, that the treatment can become sporadic again?
Based on the, I mean, I wouldn't recommend it, but the potential is, of course, if someone ends up with a complication, we'd have to put treatment on hold. But long term, my recommendation is still to continue this because it's the safest route to take treatment wise.
And that's what you had recommended in 2019?
Correct.
Okay, but it became sporadic anyways.
Well, because the insurance company wouldn't approve it.
Okay, thank you very much, appreciate it.
You're so welcome.
Thank you, sir. Mr. Egley.
Further, Your Honor.
All right. Oh, thank you. All right. Counsel, can we approach?
Your Honor, can you sit down?
No.
We have questions.
You have questions? I know, I forgot about these.
I always forget about this.
You two guys, there you go. Another one. But we can't forget that.
We cannot.
Fine?
See, I would repeat what the causation's already been made. So I understand it's no question.
That's fine. The second one is property change.
Okay, we're doing that. All right.
The second one should be the second question. I think you need to remind them of those issues. It's already been determined in court.
So this one's no.
It's already
This
been,
one's fine except for two.
yeah, it's already been determined by the court that her minus things gravis was caused by He's already testified that it's getting aggressive. That's repetitive. He already said that she's getting aggressive. I think he just explained this one here.
And that happens.
That's the same thing. You got my mind as far as your mind about causation.
Is that fine?
Yes, yes, I agree.
Just want to make sure. Yes, okay. Just wanted to make sure, counsel. Okay, ladies and gentlemen, we do have a few questions, and we'll be out of here shortly. I just want to remind everyone, as far as the questions are concerned, and I discussed this with counsel, you have to remember causation has already been established. Understand that. So I'll make sure you understand, so it's clear. Okay, we do have a question from, those are not asked. And we have a question from Mr. Dixon, panel member number 4. First question, did Lisa's medical records from other doctors mention anything about her liver failure?
So there was some mention about her history of, at that point, established autoimmune hepatitis. And so that was something that was known later on in the medical records.
All right. Next question. And this is once again from Mr. Dixon. Quote, during your time with Lisa, was there any mention of real water? Close quote.
So at one point, I have documentation of one note mentioning real water. She was getting, like, that was kind of potential cause of what happened. I mean, that's something that was mentioned. And one, just a single note. After that, really, it's more about, her care. I don't do any legal work at all. Zero. I literally pay attention to my patients. That's their focus, their well-being is my top priority. So that's when I make a recommendation, when I see my patients, that's all I do. So if someone has a legal case, things like that stays separate from what I do typically. So.
Okay, thank you, sir. We just have a couple more questions.
Sure.
And the next one is from juror number 5, Elba. Is that Lefevre? Is that fine? I just want to make sure. And anyway, question number 1. If MG can mimic ALS, how are you able to differentiate from the two?
So that's a great question. So basically we do certain testing, which I did perform on Lisa initially. ALS really affects what are called the motor neurons in your system. So we do a study called an EMG. It involves using a needle, and it acts as a probe, and we check different muscles. Patients that have ALS, essentially, we see changes on those studies. Patients with MG, we see different changes on those studies, basically. So those are some of the things that help differentiate. Also, from a serological standpoint, meaning blood work, there's no blood work for ALS particularly, whereas for MG, as we mentioned earlier, there are certain tests that did come back positive for Lisa. So that's how I was able to differentiate. And obviously over time, you can kind of, once you do the full workup and see the course of the disease, you're able to see, diagnose appropriately.
All right. And one last question, doctor, from juror number 5. At this point, had Miss King been diagnosed with her liver problems, and would that have been a contributing factor to her MG?
So that's a great question as well. So because it's an autoimmune process, she got diagnosed after my initial evaluation with her over time. So because it's an autoimmune process, I believe there's a link between her autoimmune system kicking in and it leading to MG. So I believe they're related because the body essentially, causes inflammation and kind of creates proteins that fight itself and lead to both these diagnoses. So I do think they're related in that sense.
All right, and I think that's all the questions we have from the jury. Any follow-up?
The last response about the autoimmune hepatitis contributing to the reason she ended up with myasthenia gravis, is that opinion to a reasonable degree of medical probability?
Yes.
Thank you.
All right, anything else?
No questions.
Okay, ladies and gentlemen. And we're, I guess, about 10 minutes, 12 minutes past 5, but that's not too bad because we try to finish up each witness each day because, for example, the doctor can't come back tomorrow. He has to see patients.
Thank you.
And just so you understand that, and this, of course, is reasonable. But we're done for today, and we're going to reconvene tomorrow at 9:15. And what's good about 9:15 tomorrow, that's a pretty hard 9:15 because, for example, this morning I had another 18 cases I had to deal with before we started. And it's kind of like that for me on Tuesdays, Wednesdays, and Thursdays. Fridays, we have pretty much full days. And so we'll be ready to promptly start at 9:15. I just want you to know that. Be ready to go. Just as important, too, you're admonished not to converse amongst yourselves or with anyone else on any subject connected with this trial, or to read, watch, or listen to any report of or commentary on the trial by any persons connected with this case, or by any medium of information, including without limitations, newspaper, television, radio. Remember, you can't do that. Remember that. Just as important, you can't get on social media until the trial's over with, right? We all understand that. And remember, we talked about Dr. Google and all those types of things. You don't have to ask Dr. Google. If you have questions, you ask the doctor. Remember, I told you that at the very beginning. And last but not least, do not form or express any opinion on any subject matter connected with this trial until the cause is finally submitted to you. And lastly, before you go, I just want to remind you that during the course of the trial, you might have inadvertent contact with counsel in the hallways or coming up the elevator and those types of things. And understand they're under strict ethical obligations not to talk to you. And that can include the lawyers, members of their litigation team, or the parties themselves. They can't talk to you. You understand that? And so you promise me if something like that inadvertently occurs and they don't respond, you're not going to hold that against them. Everybody understand that? Raise your hand. You know where we're going on that. Very, very important, because if that happens, they'll point it out and then we have to talk about it. But just remember, it's not done intentionally. They're actually very nice people, both sides. And they just want to follow their ethical obligations. That's all they want to do, so they won't respond. All right, Mr. Marshall.
All rise for departure of the jury.
Anything else outside the presence? We're ready? Ready to go?
Doctor can step down. correct?
Yeah, doctor, you can step down.
Thank you so much, Your Honor.
And thank you for coming down. sir. That's it, right? Go off the record?
Judge is waiting. Need something to.
We're off the record, right? We can go off the
I
record?
think we're off the record.
Okay.
Yeah, sorry, that's why I was.
I'm just asking if there's anything else.
I think you're gonna